Welcome to the Mandamus Lawyers Podcast, a legal education series about federal court remedies for immigration delays. I'm Mary, and I'm here with my co-host Aaron. Today we're discussing a question many people ask. Can I file a mandamus lawsuit without an attorney? And what are the risks if I do?
This is an important topic because legal representation costs money, and not everyone can afford an attorney. Some people consider representing themselves, what's called proceeding pro se, to save on legal fees. It's a legitimate option, but it comes with significant risks that anyone considering this path needs to understand.
So we're going to give an honest assessment of what's involved.
Exactly. We're not here to discourage anyone from exercising their legal rights, but we want people to make informed decisions with a clear understanding of what they're taking on if they represent themselves in federal court.
Let's start with the basics. What does pro se mean?
Pro se is a Latin term meaning for oneself or on one's own behalf. When someone proceeds pro se, they represent themselves in legal proceedings without an attorney. In the context of a mandamus lawsuit, it means filing and litigating a federal court case without legal counsel.
Is this allowed in federal court?
Yes, the right to represent yourself in court is well established. Federal courts allow individuals to file lawsuits pro se. However, the court will hold you to the same procedural rules and deadlines that apply to attorneys. You don't get special treatment or extra leniency because you're not a lawyer.
So the rules are the same, even if you're not trained in law.
Essentially, yes. Courts may construe pro se filings liberally, meaning they'll try to understand what you're arguing, even if you don't use precise legal language. But that only goes so far. You still have to follow the federal rules of civil procedure, local court rules, and filing deadlines. Mistakes can result in dismissal of your case.
Why do people consider representing themselves?
The primary reason is cost. Attorney fees for a mandamus lawsuit can range from several $1,000s to $10,000 or more, depending on the complexity of the case and the attorney's experience. For some applicants, that's simply not affordable.
Are there other reasons?
Some people feel they understand their own case best and want to control the process directly. Others have had negative experiences with attorneys in the past and prefer to handle things themselves. And some people are in situations where they've struggled to find an attorney willing to take their case.
Are those valid reasons?
They're understandable reasons. Cost is a real barrier for many people, but it's important to weigh the savings against the risks. If representing yourself leads to your case being dismissed on procedural grounds, you haven't saved anything. You've lost the opportunity for relief and may have to start over.
What makes federal court litigation so complex?
Federal court operates under detailed procedural rules that govern every aspect of litigation. The federal rules of civil procedure establish requirements for how complaints must be drafted, how defendants must be served, what deadlines apply, how motions are filed and argued, and how discovery works. Each district also has local rules that add additional requirements.
Can you give examples of procedural requirements?
Sure. Your complaint must meet specific pleading standards. It needs to include certain elements and be structured in particular ways. Service of process on federal defendants has special requirements under Rule 4 that differ from serving private parties. You need to serve the U.S. Attorney for your district, the Attorney General in Washington, D.C., and each agency being sued. Miss a step, and your case can be dismissed.
What happens if you make a procedural error?
Depending on the error, the court might give you a chance to fix it, or the government might file a motion to dismiss based on the defect. Some errors are fatal to the case. If you fail to properly serve all defendants within the time allowed, or if your complaint fails to state a claim, or if you miss a filing deadline, your case could end before it really begins.
You mentioned service of process. Why is this particularly challenging?
Service in cases against federal agencies and officials is more complicated than in ordinary lawsuits. Under Rule 4, you must serve multiple parties through specific methods. For the U.S. Attorney and Attorney General, service must be by registered or certified mail or by personal delivery. Each agency defendant may have additional service requirements.
What mistakes do pro se litigants commonly make?
Common errors include failing to serve all required parties, using incorrect methods of service, failing to file proof of service with the court, and missing the deadline for completing service. Any of these can result in dismissal. The government's attorneys are experienced and will identify service defects. They routinely move to dismiss pro se cases on these grounds.
Is there any flexibility for pro se filers?
Courts sometimes allow pro se litigants to correct service defects, but not always. And even when correction is allowed, it costs time and may require additional filing fees. More importantly, it signals to the court and the government that you're struggling with basic procedures, which doesn't help your case.
What about writing the actual complaint?
The complaint is the document that initiates your lawsuit and frames your legal claims. It needs to establish the court's jurisdiction, identify the proper defendants, set forth the factual allegations supporting your claims, assert the legal theories under which you're entitled to relief, and request specific remedies.
How hard is that to do correctly?
For someone without legal training, it's challenging. You need to understand the elements of a mandamus claim and an APA claim, cite the correct statutes, and plead facts that satisfy each element. You need to anticipate the government's defenses and address them. You need to frame the track factors in a way that favors your case.
What happens if the complaint is deficient?
The government will likely file a motion to dismiss for failure to state a claim. If the court agrees that your complaint doesn't adequately plead a viable legal claim, your case gets dismissed. You might be able to amend and try again, but that's not guaranteed, and it adds time and complexity.
What happens after the complaint is filed?
The government will respond, often with a motion to dismiss. These motions cite case law, argue legal standards, and contend that your case should be thrown out for various reasons: lack of jurisdiction, failure to state a claim, the delay being reasonable under the track factors.
How does a pro se litigant respond to that?
You have to file an opposition brief that addresses each of the government's arguments, cites contrary case law, and persuades the court that your case should proceed. This requires legal research skills, knowledge of how to find and cite relevant cases, and the ability to construct legal arguments in writing.
Is legal research something anyone can do?
The basic mechanics of legal research can be learned, and there are free resources like Google Scholar for finding cases. But knowing which cases matter, how to distinguish unfavorable precedent, and how to construct persuasive arguments takes training and experience. Government attorneys do this professionally. They're skilled at it.
Beyond procedure, how complex is the substantive law of mandamus?
Mandamus law involves specific doctrines and standards that have developed over decades of case law. You need to understand the three elements of mandamus, the track factors, how courts apply these standards, and how the analysis differs across circuits. You need to know what arguments work and what arguments courts have rejected.
Does the law vary by jurisdiction?
Yes, different circuit courts have different precedents, and even district courts within the same circuit may approach cases differently. Knowing the relevant case law in your jurisdiction is important for making effective arguments. An experienced attorney knows these nuances. A pro se litigant has to learn them from scratch.
Is there a risk of making legal arguments that hurt your case?
Absolutely. Making incorrect legal arguments, mischaracterizing case law, or conceding points you shouldn't concede can damage your case. Once you've made certain admissions or taken certain positions in court filings, they can be used against you. An experienced attorney knows what to argue and what not to argue.
How much time does pro se litigation require?
Substantial time. You need to research procedure, draft documents, file papers correctly, monitor deadlines, respond to government filings, and potentially attend court hearings. If you're working full-time, this is essentially a second job during the litigation.
What if someone has limited time available?
That's a significant concern. Missing deadlines in federal court can be fatal to your case. If you can't dedicate sufficient time to stay on top of the litigation, things can go wrong quickly. Courts don't extend deadlines just because you're busy or didn't realize something was due.
Is there any way to reduce the time burden?
Some services offer templates or guides for pro se mandamus filings, which can reduce the research burden. But you still need to adapt those materials to your specific case, file them correctly, and handle whatever the government throws at you in response. There's no way to eliminate the time commitment entirely.
Are there non-legal challenges to consider?
Yes, litigation is stressful, and representing yourself adds to that stress. You're making important decisions without professional guidance, facing experienced government attorneys, and dealing with the uncertainty of whether you're handling things correctly.
How does this affect the process?
Stress can lead to mistakes. When you're anxious about whether you're doing things right, you might miss details or make decisions you later regret. You also don't have someone to consult when you're unsure. You have to figure it out yourself or guess.
Is there emotional investment beyond the normal stress?
Your immigration case is deeply personal. It affects your ability to live and work in the United States, to be with your family, to pursue your goals. When you're representing yourself, every setback feels more personal because you made the decisions. Having an attorney provides some emotional buffer. Someone else is handling the legal strategy while you focus on your life.
Are there situations where pro se representation is particularly risky?
Yes, complex cases with unusual facts or legal issues are riskier because they require more sophisticated legal analysis. Cases in jurisdictions with less favorable case law require strategic decisions about how to frame arguments. Cases where the delay is borderline, not clearly unreasonable, require more persuasive advocacy to succeed.
What else increases the risk?
If you've never been involved in any kind of legal proceeding, the learning curve is steeper. If English isn't your first language, drafting persuasive legal documents is harder. If you have limited time due to work or family obligations, keeping up with litigation demands is more difficult.
Are there situations where pro se might be more feasible?
Relatively straightforward cases with very long delays, clear documentation, and strong facts are better candidates. If you have professional writing skills, are detail-oriented, have time to dedicate to the process, and are comfortable with research, you're better positioned than someone without those attributes. But even then, the risks remain significant.
How should someone think about the cost-benefit calculation?
Consider what you're saving versus what you're risking. Attorney fees might be several $1,000s, but if your pro se case gets dismissed because of procedural errors, you've lost not just the filing fee, but the opportunity for timely relief. You might have to refile, paying another filing fee, and starting the process over months later.
What about the value of your time?
Time has value too. If you spend dozens of hours researching, drafting, and worrying about your case, that's time you're not spending on work, family, or other priorities. For some people, paying an attorney is actually more economical when you factor in the value of their own time.
Any other factors to consider?
Consider the stakes. If your immigration status is critical to your livelihood, your family's well-being, or your safety, the cost of failure is high. The higher the stakes, the more it makes sense to invest in professional representation to maximize your chances of success.
Are there middle ground options between full representation and completely pro se?
Yes, several. Some attorneys offer unbundled services where they handle specific parts of the case, like drafting the complaint or reviewing your filings, while you handle other parts. This can reduce costs while still getting professional help on critical elements.
What other options exist?
Some attorneys offer flat fee arrangements for mandamus cases, which gives you cost certainty. Some offer payment plans that spread the cost over time. It's worth asking about these options rather than assuming you can't afford any representation.
Are there free legal resources?
Limited options exist. Some law school clinics handle immigration cases, though mandamus may not be their focus. Legal aid organizations sometimes help with immigration matters, but capacity is limited. Bar Association referral services might connect you with attorneys who offer reduced fees. These resources are worth exploring, but availability varies by location.
If someone decides to represent themselves despite the risks, what advice would you offer?
First, invest significant time in learning procedure. Read the federal rules of civil procedure, especially the rules on pleading, service, and motions. Read your district's local rules carefully. Understand every deadline and build in buffer time.
What else?
Second, study successful mandamus complaints and briefs. Some are available through court electronic filing systems. Seeing how experienced attorneys structure arguments and cite authority can guide your own drafting. Don't copy them verbatim, but learn from their approach.
Any other guidance?
Third, be meticulous about documentation. Keep copies of everything you file, everything you receive, and every deadline. Create a calendar with all due dates. Triple check your work before filing. One small error, a missed signature, an incorrect date, a service defect, can derail your case.
Let's summarize the key points from this episode.
First, filing a mandamus lawsuit, pro se, without an attorney is legally permitted, but carries significant risks. Federal court procedure is complex, with detailed rules governing pleading, service, deadlines, and motions. Errors can result in dismissal of your case. Courts hold pro se litigants to the same procedural standards as attorneys, and government attorneys are experienced at identifying and exploiting defects in pro se filings.
Second, Beyond procedure, mandamus law itself is complex. Constructing persuasive legal arguments requires understanding case law, the track factors, and how courts analyze delay claims. Responding to government motions to dismiss requires legal research and writing skills. The time commitment is substantial, and the stress of self-representation adds to the challenge.
Third, before deciding to proceed pro se, carefully weigh the costs and risks. Consider the value of your time, the stakes of your case, and the consequences of failure. Explore alternatives like unbundled legal services, flat fee arrangements, or payment plans. If you do proceed pro se, invest heavily in learning procedure, study successful filings, and be meticulous about deadlines and documentation.
Thank you for listening to the Mandamus Lawyers podcast. Mandamus Lawyers is a law firm focused exclusively on federal court litigation for immigration delays. Visit mandamuslawyers.com.